Welcome to Let's Talk Law, where we always bring to your doorstep simple legal analysis. And in this episode of Let's Talk Law, we are going to be explaining the draft of joinder of parties. And one of the things I'd like you to note in this draft is that the first thing you do in a draft is to write the heading of the court. And what determines the heading of the court is the particular court where you are instituting the action and the state in which you are instituting the action. In this particular draft, we are instituting our action in Lagos State and we are instituting our action in the High Court. If you use the High Court, you will always have judicial division. So our case is instituted in the High Court of Lagos State. What judicial division? We have the Lagos Judicial Division holding at Lagos. Then immediately after that, to your right, you have the suit number. Ensure that you don't fill any number in the suit number because it is the duty of the registrar to fill that spot, so you leave it empty. Immediately after that, you come to the parties. What begins the parties is between. The case is between this person and this person. So for a motion for joinder, you will have two and joining the parties. The reason is because you have the claimant and the defendant. Then you also have the party that you want the court to join. In the substantive suit, you have just the claimant and the defendant. Your claimant can be more than one, and your defendant can also be more than one. So you write the claimant and the defendant. But in this sample case, in this sample draft, we have just one claimant and one defendant. Then a motion, anybody bringing an application for motion is called an applicant. That is why after claimant, you see that we slashed it and wrote applicant. The reason is because there is already a pending suit in the courts. There's a pending suit in the courts. Then someone is now applying that this suit that we have, I want you to join a party to it. That is the person now saying that please join this person to it. The person is called the applicant. In this case, it is the claimant that is saying join the third party. That is why we slashed the claimant with applicant. Then after that, we have the defendant. The defendant is the respondent because the defendant will be responding to the application. Then after that, you now have the name of the party that you want them to be joined. Look at the designation. It is party sought to be joined. Now, the next thing is you write the heading. What is the name of this draft? It is a motion on notice. Then after that, you have the rule of courts that this draft is brought under. It is brought under Order 15 Rule 1. Write it just the way it is. Write it this way. If you do not remember the particular rule, just write Order dash Rule dash. Then Order 43. Know that in Lagos State, for motion, when you want to draft any motion, just know that you use Order 43. So you can just put that at the back of your mind that in Lagos State, when you want to draft a motion, you always have Order 43. Then you now support it with any other order for that specific application you are writing for. Joinder of party is Order 15 Rule 1 of the High Court of Lagos State Civil Procedure Rules 2019 and under the inherent jurisdiction of this honorable court. Then you see this introduction, take notice, blah blah blah. That particular introduction, you have to cram it just the way it is here. Then after you get to, then in this dates area, please don't fill the dates. It is the duty of the registrar to fill the dates that the court is going to sit on your matter. Do you get that? So you now have at the hour of 9 o'clock forenoon or thereafter. The reason why it's usually the hour of 9 o'clock forenoon or thereafter is because the court sits by 9. Forenoon or thereafter, it means that the court may sit after 9, but then the minimum time is 9. But the court can choose to sit maybe by 12 or any other time as the case may be. But you always write at the hour of 9 o'clock, forenoon, or thereafter. Thereafter already covered any time that the court now chooses to sit. Then look at this place. As the counsel for the claimant applicant shall be heard praying this court. You want to pray the court to do something. That's why that place is like that. You are praying the court. You are praying, my Lord. You are telling my Lord, please grant this order. Make this order. Now, the reason why we have claimant applicant here is because it is the claimant that is bringing the application. It's not the defendant that is bringing the application. Then, what do you want the court to do for you? You are telling the court, number 1, an order joining the name of the party sought to be joined either as a co-defendant or co-claimant. Please, it is only one you will choose out of the two. I wrote the two there so that you can know that a party can be joined as a claimant or the party can be joined as a defendant, as the case may be. Your scenario will tell you which one the party should be joined as. Do you get what I'm trying to say? Then you now have the second part, which is and such further orders as the court may deem fit, because the court can make another order apart from the order that you prayed the court to make. So that particular one is called the omnibus clause. The omnibus clause is usually in every motion. Now, after that, you now write dated this dash day of that. This particular dated this dash day of dash, it is the date that you drafted the application. That's the day you drafted the application. It could also be the same day you took the application to the registrar. Do you understand? So you will write it. You are the one that will fill that date. Most times is usually the date of your examination or test, as the case may be. Then immediately after that, the lawyer who drafted the case will sign. This dash that is before Z.E. Olowolekomoro Esquire is for signature. Please always ensure that you sign, because any unsigned document is just like a worthless paper, like in the case of Okafor versus Inweke. So please always ensure that you sign, because signature carries mark, and every mark that you can get matters in the bar finals. Every mark matters. So please ensure you sign all of your documents. Then you write the name of the lawyer. Ensure that it's the name of the lawyer that you wrote immediately after the signature, because it's not the law firm that signs. It is the lawyer that signs. So you write the name of the lawyer. Then who is the lawyer? The lawyer is the claimant applicant solicitor. Then you write the name of the law firm. Then you now write the address of the law firm. You now write the phone number and the email address. Why are you writing all of this information? Don't forget that the defendant respondent may want to respond to the application. And if they want to respond to the application, they will need a place to submit the application. They will need a place to serve the other party. So they will serve the other party at their address. That's the essence of the address, the phone number, and the email address. Maybe in case of substituted service, maybe they do not want to receive service. They are evading service. Then if there's a need for substituted service, another application will be made to the court for substituted service. If the court grants it, then they can serve them via their mail. Now, after that, then you now write the address of the defendant respondent. That's the person you are serving it to. Do you get what I'm trying to say? Please. And then you write the address and every other information as seen here. Now, this second draft is also for joinder of parties. However, in this second draft, the difference is that Zinzinkola Achara, which is the party seeking to be joined, is now the applicant. That means is the person saying that, please join me to this suit because I'm a necessary party in this case. Join me to this suit. Now look at it. You will see that Zinzinkola Achara being the party seeking to be joined. The initial one was party sought to be joined because it's another person that is seeking that they should join Zinzinkola. But now it's Zinzinkola that is seeking to be joined. That's why it changed here to party seeking to be joined, and is the one applying to the court. That's why we have /applicant. Now that is the one applying to the court, then you notice that on top, the claimant has become a respondent and the defendant has also become a respondent. Now that we have two respondents, that means we have to serve two people. We have to serve two people. Now, another thing you will notice here is, if you notice in the introduction part, come over to the third line, you see that counsel for the party seeking to be joined /applicant. In the initial one, you realize that it was the claimant /applicants that we talked about. But in this particular one, you see that we wrote the counsel for the party seeking to be joined, because it's the counsel for the party seeking to be joined an applicant that will be telling the courts that, please join my client, please join my client. Do you understand? So then the order remains the same, then the dated this dash day of dash, then the name of the signature, don't forget, of the lawyer, the name of the lawyer, the designation of the lawyer, the party seeking to be joined or applicant /applicant solicitor, then the address and every other thing that needs to be written. Now, in this place, you will realize that we have two people that are going to be served. Those are the claimant respondent and the defendant respondent. I will also want you to take note of something. Look at this. For the claimant respondent, we are serving his lawyer. We are serving the lawyer. We are not serving the claimant respondent directly. So you can choose to serve the claimant respondent directly, or you can also choose to serve the lawyer of the claimant respondent. The reason why we are serving the claimant respondent's lawyer is because we know the claimant respondent lawyer. Don't forget that there is already a pending litigation. There's already a substantive suit. So since there is a substantive suit, then you will know that, okay, there is a lawyer. So if you have the address of the lawyer handling the case, then you will now write C/O. The meaning of C/O is, it means that the application is in, you are giving it to the lawyer, you are serving it to the lawyer in care of. So in care of, the application is in care of the counsel of the claimant's respondent. Do you understand? Then you write the name of the lawyer, then the address and every other thing. Then you can also write, look at the second one now. We wrote the defendant respondent directly. We did not serve their lawyers. I hope that with this explanation, you now know how to draft a joinder of parties. In case you have any question, please don't hesitate to drop your question in the comment section. Every question is going to be attended to. Thank you.